Please. Like people, Lordship's kindly, Lordship knows that there in state administrative tribunal, there are no benches available. This matter was filed so that the matter is taken up in view of the non-availability of bench, and directions be passed for speeding up the process of recruitment of the honorable benches.
That is already being done in a proceeding.
This
That
matter
is already been taken up by the honorable single judge. We have seen an order, two orders.
That is one of the honorable single judge.
Yes.
This matter, in absence of that matter, I'll be praying.
So therefore, what is the issue? What needs to be done immediately?
The seniority and
Seniority is, there is no
I
urgency.
have challenged an order, if your Lordship kindly, includes the.
Wait for some time. If it was something which order was required to be passed immediately, we could have understood. Seniority, it can wait for some time. Yes.
Well, praying your Lordship to file the writ petition without certified copy. I have the internet copy.
Date of order?
Order 1st September. We applied 2nd September, but could not get it. And urgency is that, my lord, this is the matter where, my lord, your Lordship was pleased to give direction upon the rail authority to consider the document filed by the member of the association, coal and ash worker of the railway authority.
It's not that urgent.
No, my lord, what has happened? After your Lordship's order, I filed contempt application. In the contempt application, your Lordship was pleased to give me liberty to file appropriate application before the tribunal so that the earlier order by the tribunal be complied with. Now, my lord, what has happened, my lord? We submitted to the document. They had never seek any document from us. No scrutiny. Now they rejected our claim. And we are fighting since 2004. This was the consent order before your Lordships by the railway board.
All right, we can allow you to file, but this side will not be in a position to take up. We are making it very clear.
Up, my lord, the worker, my lord, is
cannot be done. Please try to bear with us. Cannot be done. We cannot.
Leave be granted, my lord, to file.
Yes, that you may file. You have given an undertaking, obviously.
Yes, absolutely. Yes. Absolutely, my lord. Obliged, my lord. Grateful.
Number 2. Lordship, for in item number 2, I am for the appellant. May it please your Lordship, we had filed 2 separate applications for substitution. One is CRAN 4, CRAN 5. May it please your Lordship, I am for the respondent number 9 and 10.
Yes. You have got the substitution application?
No, my lord, not yet. We have served a copy here, Lordship.
He is saying no.
For 4 and 5, both of the application copy served.
Yes. Why you are saying you have not got a copy?
I'm for the 9 and 10, my lord. I didn't get. I have not received. Lordship, I will serve another. And it's been a long time.
Long time means it has to be reserved.
No, my lord.
What do you mean long time? Either
I
it
beg
is
your
served
pardon.
or not served.
I beg your pardon. I beg your pardon. I beg your pardon, my lord. I beg your pardon.
I will serve a fresh
copy. I beg your pardon, my lord. I will serve a fresh copy upon all the respondents.
That copy of the.
Next week, Vice President.
My lord, yesterday I was drawing your lordship's kind attention to two particular paragraphs of the affidavit in opposition my learned friend has filed. One was paragraph 6 of the affidavit in opposition with regard to the release of the matter by Their Lordship the Honorable Justice Bosak, sitting with Justice Sabbar Rashdi. Affidavit in opposition of the respondent, of the applicant.
Yes, you said that there is no such categorization
Right.
and that
But-
it was a lame plea or lame excuse.
Yes. My submission was that there was no classification of this sort.
No categorization of that.
Therefore, in my respectful submission, my lord, this stand of the learned counsel on the other side or rather the other petitioner does not approve, is not subject to any approval, my lord, subject to your lordship. The other thing I was mentioning, my lord, in the affidavit in opposition, in the very beginning paragraph of paragraph 3 of the affidavit in opposition. In paragraph 3, subparagraph A. Subparagraph A. The present application, that means the application for recall. The present application has become infructuous. Why? By virtue of the judgment and order dated 21/1/25 passed by the Honorable Justice Joy Sengupta. When I have made my submission, Justice Joy Sengupta also relied upon this particular order. The order which my lord come for a recalling.
He has relied on this order.
Yes. An order made without assignment and without determination, even in spite of drawing the attention of my Lord Justice Sengupta, Justice Sengupta relied upon that order. And my Lord, I submitted that in course of showing the decisions on this point, that an order made without determination in appropriate manner cannot be relied upon for any purpose. And therefore, if it cannot be relied upon, an unreliable order cannot make an order, cannot make an application infructuous. The second name of the submission in subparagraph A of paragraph 3 is that Justice Tapobrata Chakraborty and Ritobroto Mitro also delivered a judgment upon relying upon that particular order. In 3 subparagraph A. And later on went up to the extent of saying that the Honorable Supreme Court has delivered a judgment dismissing the writ application, dismissing the special leave petition against the order of Justice Tapobrata and Ritobroto Kumar. Therefore, the application for recalling before your lordship has become infructuous. It has become infructuous. But even if the learned Supreme Court, the Honorable Supreme Court, has relied upon an order which is made without determination, without assignment, cannot be relied for any purpose, is not my saying. It is the saying of the Honorable Supreme Court. It is the saying of the Honorable Supreme Court. Now it is infructuous, yes. If I am forced to rely upon that submission that yes, it is infructuous, it can be said infructuous only when it can be said infructuous by completely ignoring the law laid down, even by the Honorable Supreme Court. Well, I would not go up to the state of saying that, well, in this country, the process of legislation is not only vested with the legislators, but legislation is also made by the Supreme Court, and that is being given, my lord, and judgment delivered by the Supreme Court takes the sanctity of a law under Article 142 of the Constitution. So this is my own submissions on so far as the facts relating to the case. Now I shall try to place before your lordship some judgments which I want to rely. The first in this series, my lord, is a judgment of a division bench, my lord, of this honorable court. Let me start with from Calcutta. This is a judgment, my lord, reported in AIR 1990 Calcutta 168. AIR 1990 Calcutta 168 by the then Chief Justice P.D. Desai, later on the Supreme Court judge, sitting with Justice Shamal Sen. This is a division bench judgment. My lord, it is also, I have a copy AIR 1990, AIR 1990 My lord, it is the corresponding report is, my lord, this is, I am giving, my lord, 2 copies. My lord, though it is not AIR, but the parallel reporting I am giving. My lord, this is the case of Sohanlal Baid versus State of West Bengal. My lord, in this judgment, my lord, the copies I have given to your lordship, my lord, unfortunately, the head notes are not there. The head notes are to be found, my lord, in the AIR 1990. And I have given them a cross-reference, my lord, in my handwriting on that. I have given that. It is reported in 1990, Calcutta. But unfortunately, the head notes are not there. My lord, may I place the judgment, my lord? My lord, may I proceed, my lord?
Just
Yes,
give us a
my
minute.
Constitutional body actually. Constitutional body. Constitution আছে এখানে? সারাদিন।
Yes.
My lord. My lord, in the very shockingly, my lord, in the head notes, my lord, the judgment has been given, my lord. I'm just placing it for your lordship's kind consumption. Constitution of India, Article 220, it is not there, my lord. Unfortunately, it is only in the AIN 1990. When I'm placing it, I'll give the copy, this copy also. My lord, the judgment, my lord, the entire text of the judgment is there, but the head notes are there, not there. But I'm just reading for your lordship's convenience, then I will give this copy also, the head note part. But in the head note, my lord, it is said,
We don't know if the paragraph is matching this, but probably you will be referring to.
well, let me start from the judgment, the text of the judgment. It is matching.
Huh?
One of the paragraph, the appeal is taken up for hearing by treating it as included in the day's cause list. As included in the day's cause list. Yes. The appeal arises out of an order passed by the trial court on 6th April in CR number so and so. Paragraph 2. The appeal raises the question as to the power, authority, and jurisdiction of the trial court, Mr. Justice Bhagavati Prasad Banerjee, to pass the said order. The appellant HON'BLE both is the original writ petitioner. 8 respondents herein initiated a proceeding against the appellant and a few others including Chaganlal Baid and Kundanlal Baid under section 156(3) of the Code of Criminal Procedure in the Code of the Additional Chief Judicial Magistrate Shialdah, seeking investigation in respect of an alleged offence punishable under section 380 of the Indian Penal Code. The said court directed the fifth respondent herein to inquire into the complaint and submit a report. The case was thereupon registered as Chitpur PS case number 94 dated April 23, 1986. The said proceeding gave rise to 3 separate writ petitions, with identical prayers to the effect inter alia that the investigation and the consequential proceeding pending in the court below be recalled, rescinded, cancelled, and or revoked, and that further proceeding be stayed. The writ petitions were filed individually by the appellant and Chaganlal Baid and Kundanlal Baid. In the writ petition filed by Chaganlal Baid, an interim order of injunction was passed on April 28 to the effect that police authorities would be at liberty to proceed with the investigation, but would not file the final report without the leave of the court. Hence, however, in the other 2 writ petitions filed the appellant, Kundanlal Baid, respectively, interim release was granted, staying further investigation in the case. That was the dispute. To be precise, in CR number 71388 filed by the appellant, while entertaining the writ petition December 24, 1987, an interim order operative till 2 weeks after the Christmas holiday was passed, restraining the respondent from proceeding with the investigation on the basis of Chitpur police station. When ultimately rule was issued on February 3, interim relief was granted in the following terms. Interim order already passed will continue till disposal of the rule, with liberty to the respondent to apply for vacating and varying the interim order upon notice to the petitioner. An application dated March 3, 1989 was filed in the registry by the 8th respondent herein, praying that the order aforementioned passed on February 3. What was the order? It is within inverted comma it is given. The order aforementioned passed on February in the writ petition instituted by the appellant be recalled and set aside, and not any further order or orders may be deemed fit proper. Was served in the application that there was conflict between the interim order aforesaid interim order granted Chagalal, inasmuch as in the latter case investigation was permitted to go on but for the filing of the final report without the leave of the court was injuncted. Without the leave of the court was injuncted. Whereas investigation was totally barred in the present case, was submitted the total prohibition against the investigation was causing great hardship, prejudice, and that therefore the order granted should be recalled. The said application was listed and reached hearing before Justice Bhagavati Prasad Banerjee. The material part of the order passed by the learned judge upon the said application reads as follows. In my view, the case of 3 different writ petitioners was against Chitput PS case, and the grounds of challenge were the same, and that contradictory orders were passed because of the fact that the 3 writ petitioners were moved separately on different dates, and it was not pointed out before this court that the other writ petition against the said PS case was pending. If the existence of the other writ application and the interim orders had been pointed out to this court in that view, it was the duty of the court to see that no conflicting orders are passed in this case. There were 3 cases by different courts, by 3 different writ application, and the different interim orders relating to the same police station case have been passed. Therefore, the interim orders should be recalled and should be made uniform so that there is no conflict in the interim. When this court passed an interim order in CR, it is 1285287, whereby the police authorities were given liberty to proceed with the criminal case, but they were restrained from filing any final report without leave of the court. The same interim order should be deemed to have been passed in this court in this writ application, as also it should be deemed to have been passed in this writ application. I make it clear that the police authorities would be at liberty to proceed with Chitput PS case in accordance with law, subject to the condition that in case any charge sheet has to be submitted, the same should be submitted without obtaining the leave of the court. This order I am passing considering the fact this court has passed inconsistent interim order in the same matter, overlooking the order passed in other cases, and that unless interim order is modified, the interim order passed in other case should not be given effect to, as because this court has passed so and so. So, hence the present appeal. It was an appeal. Here it is a recall application. Yes, my lord. But let me proceed. How it has been dealt with by this court.
No,
Yes.
please. Actually, we have gone through the facts, therefore we are saying.
Yes. So it was strenuously urged on behalf of the petitioners that 7 appellant that Mr. Justice Bhagavati Prasad Banerjee had no jurisdiction to pass the order. The pass the orders impugned in the appeal on the day. For the question, he was assigned that the work of hearing parter and contempt matters, and that since the writ petitioners in the present case was not a parter matter, yet then he heard it and he made an order. Then paragraph 11. The High Court Act or the Charter Act 1861, hereinafter called the Charter Act, by the learned division bench goes to the root of the very thing. To the root of the very thing. Which authorized the establishment of High Court of Judicature in India, Section 1 of the said Act, providing inter alia that it shall be lawful for Her Majesty by latest patent to erect and establish High Court of Judicature of Fort William for Bengal Division of the Presidency Division, Fort William, and by latest patent to erect the established like High Court of Madras and Bombay for those presidencies in respectively, and that the High Courts to be established under such latest patent should be established. Publication of such latest patent in the same presidency or such other time as in such latest patent may be appointed in this way. But I do not know whether in course of the hearing this latest patent issue will come. If it comes, I am ready to answer to that. Latest patent may be appointed in this way. Section 13 of the Charter Act provides that subject to any laws or regulation which may be made by the Governor General in Council, the High Court established in any presidency under the said Act may by their own rules provide for the exercise by one or more judges of the Division Court, constituted by two or more judges of the said High Court. Lordship says, my Lord, even the Charter Act provides that. Well, it is the rule of the High Court, they will provide. And the rule of the High Court is there, the appellate side rule. It has been, my Lord, it has been dealt with in this particular judgment. By one or more judges, division court constituted by two or more judges of the High Court of the original and appellate jurisdiction vested in such court in such manner as may appear to such court to be convenient for due administration of justice. Section 14 provided that the Chief Justice of each High Court shall from time to time determine what judge in each case shall sit alone and what judges of the court, whether with or without the Chief Justice, shall constitute a division bench. The latest patent dated May 14 for the High Court of Judicature of established in Bengal in accordance with the provisions of Charter Act was transmitted to the Governor General of India in Council in March 15. Sir Charles Hood, Secretary of State by latest patent, were afterwards invoked by further latest patent dated 2865. Clause 36 of the latest patent dated December 28, 1965, in its original form, provided inter alia that any function which were thereby to be performed by the High Court of Judicature at Fort William in exercise of its original or appellate may be performed by any judge, by any division thereof, appointed or constituted for such purpose, under the provisions of the 13th section of the aforesaid Act. Of the 24th and 25th PS of region, a reference is expected in the extracted provision aforesaid is to section 13. The said extracted portion was substituted by the words in pursuance of section 108 of the Government of India Act by the amended latest patent 11 March 1990. Paragraph 35 of the dispatch from the Secretary of State accompanying formal latest patent mentioned inter alia that clause 36 referred to the powers of single judge or division appointed or constituted under the provisions of section 13 of the Charter Act, and that by section 14 the power of determining time to time what judge in each case shall sit and what judges shall constitute division was placed in the hand of the Chief Justice. There must be judicial discipline. Well, long back, my lord, it is the imperial legislation, they also thought it. And my lord, the Constitution of India has given that approval. Pursuant to that, my lord, the appellate side rules or the original side rules of your lordship's court have been framed. which is in vogue. The Charter Act was repealed and re-enacted with slight modification by the Government of India Act 1915. Section 106 of the said High Court of the said Act provided inter alia that several high courts are courts of record. That is what I am saying. That your Lordship's court is a court of record. A twisted record, a falsified record, a record without assignment, a record made in mayhem. Would it remain there? It is a court of record. The sanctity of a judicial record has to be maintained. And it is the bounded duty of this side also to mention before your Lordship, today or tomorrow, yesterday or today or tomorrow. It is our bounded duty. But here there is something wrong. May your Lordship be pleased to take it off, or as your Lordship seems fit. Section 106 of the said Act provided inter alia several high courts are courts of record and have all such powers and authority over or in relation to the administration of justice, including power to make rules for regulating the practice of the court as are vested in them by latest patent, and subject to the provision of the latter patent, all such jurisdiction, and subject to the provisions. Your Lordship will kindly mark this. Subject to the provisions of the latter patent, all such jurisdiction, powers, and authority are vested in those courts, respectively, at the commencement of the said Act. Section 108 says as follows. It reads as follows. Each High Court may by its own rules provide, as it thinks fit for the exercise of one or more judges, or by division court constituted by two or more judges of the High Court of the original and appellate jurisdiction vested. 2. The Chief Justice of each High Court shall determine what judge in each case is to sit alone, what judges of the court, whether with or without Chief Justice, are to constitute the several division bench. Government of India Act 1915 was repealed and re-enacted with modification. My lord, total judicial history, my lord, has been given laid down in this particular judgment. Section 223 of the said Act reads as follows, the amended Act. Subject to the provision of this part of this court to the provisions of any order in council, made under this or any other act to the provision or any other order, made under the Indian Independence Act, and to the provisions of any act or appropriate legislature enacted by virtue of powers conferred on that legislature by this act. The jurisdiction of and the law administered in and any existing High Court and the respective powers of the judges thereof in relation to administration of it, including any power to make rules of court and to regulate the sittings of the court and the members thereof sitting alone or in division, shall be the same as immediately before the establishment of the dominion. The Government of India Act 1935 was repealed by Constitution of India Article 225 of the Constitution. Insofar as it is relevant for the present purposes, reads as follows. Jurisdiction, Article 225. Jurisdiction of existing High Courts subject to the provisions of this Constitution and to the provisions of any law of the appropriate legislature made by virtue powers conferred on that legislature by this the jurisdiction of and the law administered in any existing High Court and respective powers of the judges thereof in relation to administration of justice, including any power to make rules of court and regulate the sittings of the court, and the members thereof sitting alone or division, shall be the same as immediately before the commencement of the Constitution. So it has not been scrapped. My lord, the leadership of the Chief Justice. Thereafter, paragraph 17. In National Saving Trade Company, so and so, it was ruled that power that was conferred by Section 108 of the Government of India could be exercised from time to time with reference to jurisdiction, whether existing at the time of coming into force of the said act or whether confirmed by subsequent legislation, and that the said power still subsists and that it has not been affected in any manner whatever either by the Government of India Act 35 or by the Constitution. On the other hand, it has been kept alive and reaffirmed with great vigor by those statutes. It was further observed that the power is there and continues to be there and can be exercised in the same manner as it could be exercised when it was originally conferred, subject, of course, to the alteration by any appropriate legislation. It is that clear that the Chief Justice of the High Court has the constitutional power to determine. Question of determination I have raised here. It is thus clear that the Chief Justice of the High Court has the constitutional power to determine and what judges of this court, whether with or without Chief Justice, are to be constituted. The several division, whether with or without the Chief Justice, are to constitute the several divisions. In other words, the function of assignment of the judicial business amongst the judges of the High Court, whether sitting singly or in division, is entrusted by law to the Chief Justice. And the judge or judges derive jurisdiction to deal with these side cases assigned to them by virtue of the determination made by the Chief Justice. Was there any determination after Justice Bosak to release the matter? I am not raising the question as to whether the determination with Justice Bosak was there or not, because that is not assigned matter. I am just asking this question to myself. Was there any determination that the Chief Justice will take up writ appeals on the day when there was an order? Was there any determination? If it was there, I am out. But in so far, my lord, my humble strife went on. I've tried to find out whether there was any determination at all. It was no determination, no assignment. My lord, my emphasis to my submission before your lordship is not my angers.
No, you have submitted yesterday. You have.
It was my very
Emphasize
humble
this point.
submission.
Yes.
But with all the command I have in my force, but I place before your lordship that an order is made by a court without jurisdiction, even if it is presided over by the Chief Justice. Are you not transgressing your own order? Are you not transgressing the law? Is it not an arbitrary order? Not a question I am asking for myself and placing it before your lordship for determination. Question is not as to what is the effect of it. Well, I am not bothered about the effect. The effect might have suffered to my ruin. But should, even after the ruination of my cause, should I allow, as an honest citizen, to carry on a tainted order, to remain in a court of record? Being not only as a citizen, a conscious citizen, but also as an officer of the court, is it not my duty that I shall say, my lord, this order cannot remain? Because it was an order without authority, because it is an order without determination, even if it was an order by the Chief Justice has transgressed the constitutional power which the Constitution has given to him. Then it goes to say, my lord, there are more. I will place, my lord, the latest judgment of the Supreme Court on this one. But we cannot say anything about the Supreme Court. Huh? But in catena of cases, the Supreme Court will say, well, the High Court did not give any reason. No? It is an order without reason. But we can give an order without reason. SLP dismissed. Why, Baba? The law which you laid down is binding upon the high courts. And the law is not binding upon you. যে রক্ষক সেই ভক্ষক. Unfortunately, my lord, in a case when I appeared, my lord, before, in my life, my lord, once I have appeared before the Supreme Court. In my long career. And that was also because of the obstinate request of my friend, my lord, this gentleman. This gentleman. And it was a learned judge, my lord. Oh, you don't have a case. I said, I didn't open my case. The SLP is dismissed. I didn't open my case. Oh, you don't have a case. I don't know whether the learned judge has at all read my case. I don't know whether I'm making any content. And even if it is a contemporary. Then, my lord, I am preaching it. কি হচ্ছেটা কি এ দেশে সেই মহিলা আবার এখানে গভর্নর হয়ে আসে বুঝলে I'm going a little further. It's a personal thing, my lord. But unfortunately, I was placed before in the United Nations, in the General Assembly. Sardar Swaran Singh was the External Affairs Minister. And the Indian High Commissioner was my lord B.K. Nehru. I was sitting with him. A particular, my lord, resolution came against South Africa. I said, I am going to make a statement against South Africa. B.K. called, asked me, what is the statement you are going to make? I said that the designation of South Africa, I mean the what is called the recognition of South Africa to sit here in the original, in the United Nations General Assembly should be taken off. He said, no, you cannot do that. It's a very harsh thing, you cannot do that. I said, this is the harsh thing that Gandhi said. That because you are doing the apartheid, no apartheid, against which 1001 resolution has been made in the United Nations, they cannot sit here. সত্য যা তা বলিব Lordship, kindly pardon me. It's my humble submission before your Lordship. Then, my lord, it says, the following observation in a state of Maharashtra versus so-and-so, Supreme Court, 1982 Supreme Court. The Chief Justice is the master of roster. It is again the Supreme Court. He has full power, authority, and jurisdiction in the matter of allocation of business of High Court, which flows not only from the provisions contained in subsection 3 of section 51 of the Act, but inheres in him in very nature of things. A reference to the statutory provisions in above extracted portion in section 51 of subsection 2 of the State Reorganization Act, which inter alia provided that the judges of the division courts of the High Court for a new estate may also sit at such other places in that state as the Chief Justice may determine. Even where your Lordship will sit, that also the Chief Justice will determine if there is any court. That means, you look at the Andaman Circuit bench. Even in which bench which judge will sit will be determined by the Chief Justice, because he is the master of the roster. And if I am the master of the roster, I can violate it. A reference to the statute so-and-so. A reference to the statutory provision in above extracted portion is to section 51 of the State Reorganization. I felt. Paragraph 20. Pramotanath Talukdar Saroj Ranjan Ayaya 1962 against Supreme Court, which reached the apex court from decision rendered in 2 criminal division cases by a special bench of 3 judges of the Calcutta High Court. Similar observations are found to have been made. The question in that case was whether, in the absence of provision, similar to provision 2 of Rule 1 of Chapter 2 of the rules of the High Court at Calcutta Appellate Side Rules. In Sub-Rule 1 of Rule 9 of the said chapter, it was open to a division bench which initially heard the criminal divisions to refer them to the Chief Justice for the constitution of a larger bench. S.K. Das J., who delivered a minority judgment, dealt with this question elaborately, and majority judgment agreed with the conclusion on this particular point. Arrived at the minority judgment, S.K. Das observed that it was clear from the rules in Chapter 2 of Rules of the High Court of Calcutta Appellate Side that the constitution of benches is a matter for the Chief Justice, and that it was open to the Chief Justice on a reference by the division bench to constitute a larger bench to consider criminal division. The learned judge proceeded to make the following further observation. But a single judge's judgment, when a minority judgment is being confirmed by the majority judges, 2 other judges. And this is the judiciary. I am also in agreement with the view expressed by the special bench that absence of a proviso to Rule 9 in Chapter 2 corresponding to the provision of Rule 1 does not take away the inherent power of the Chief Justice to refer any matter to a bench of 3 judges. I further think that the Chief Justice must have the inherent power to constitute a larger bench in special circumstances. Take, for instance, a case when one judge of the division bench feels, for a sufficient and good reason, that he should not hear the case. It is obvious that in such a case the matter must be referred back to the Chief Justice for the constitution of another bench. The Chief Justice, I think, must possess such an inherent power in the matter of constitution of benches, and in the exercise thereof, he can surely constitute a larger bench. But this is with the constitution of bench, not much with us. But the question, my lord, which I am saying that, well, for all purposes, it is the Chief Justice, not only determination, not only which judge will sit with whom, not only if there is a circuit bench, it is the Chief Justice, then the Chief Justice is the master of the roster. Chief Justice is the master of the administration of the entire High Court. The administrator means not only executive administrator, but also the judicial administration. The entire judicial administration, he is the pater familias of the judicial. Although the observation with regard to the inherent power were made in these 2 cases in varying contexts, those observations have general applicability and aptly bring out the 2 legal positions with regard to the inherent power of the Chief Justice in the matter of constitution of benches and allocation of judicial business of the High Court among the judges sitting singly or in several division benches. Apart from the fact that such power vests in the Chief Justice, under the fundamental law aforesaid and also inheres in him, the rules of the High Court. But it is an exhaustive decision. Now, apart from the fact that such power vests in the Chief Justice under fundamental laws aforementioned, and also inheres in him, the rules of the High Court Calcutta recognize and confer such powers on the Chief Justice. So, the foregoing review of the constitutional and statutory provision in the case law on this subject leaves no room for doubt or debate that once the Chief Justice has determined what judges of the court are to sit alone or to constitute several, and also allocated the judicial business of the court among them, the power and jurisdiction to take cognizance of the respective classes or categories of classes presented in a formal way for their decision according to such is acquired. My lord, the adjudication of a particular lease before a bench, whether sitting singly or a division bench, can only be undertaken, or I again emphasize, can only be undertaken if it has been assigned or if the Honorable Chief Justice has determined that particular branch of cases, that particular, I say, the cases, that particular types of cases to be determined. It is only that can be taken. Well, this is for the ratio of the decision. In my respectful mind, this is the ratio of the decision. To put it negatively, the power and jurisdiction to take cognizance of and to hear a specified category of cases and to adjudicate and exercise a judicial power in respect of is derived only from the determination made by the Chief Justice in exercise of his constitutional, statutory, and inherent power, and from no other source, and no cases which is not covered by such determination can be entertained, dealt with, or decided by the judges sitting singly or in division courts till such determination remains operative. Till any determination made by the Chief Justice lasts, no judge who sits singly can sit in a division bench, nor can a division bench be split up, and by both of judges constituted such bench sit singly or constituted with another, take any other. Therefore, by this, in paragraph 23, the entire thing has been very circumscribed. And my lord, in the AIR, in the reported in the AIR, my lord, this particular paragraph has been showed in the short notes, in short notes. Even cases which are required to be heard only by a particular judge or division bench, such as parted matters, review cases, cannot be heard unless the judge concerned is sitting singly or the same division bench has assembled as has been taking up judicial under the extent determination. I am not an angst. I bow down to the law laid down by these benches, by my judiciary. Such reconstitution being take place only if the Chief Justice especially determines accordingly. The following observations of Vasudev Mukherjee so and so in Allahabad so. It is clear to me on a careful consideration, that is a Allahabad decision quoted here. Chief Justice who has the right and the power to decide which judge is to sit alone case such as can decide further. It is again for the Chief Justice to determine which judges shall constitute division benches and what work those benches shall do. That is determination of what? Under the rules of this court, the rule that I have quoted above, it is for the Chief Justice to allot work to judges. And the judges can do only such work. My lord, the judiciary does not, my lord, use a word in extravagance under my respectful submission. The judiciary is very careful. I think, my lord, even more than the diplomats. The judiciary is very careful to use the language or the word. Is very careful, very cautious. That is why, my lord, state. I have quoted, it is for the Chief Justice to allot work to judges, and the judges can do only such work as is allotted to them. My lord, if extravagantly a court, my lord, a judiciary extravagantly uses word, then there will be no public respect for it. So it is used, can do only such work. It is not, in my view, open to a judge to make an order which could be called an appropriate order, unless and until the cases in which he makes the order has been placed before him for orders, either by the Chief Justice or in accordance with his direction. I have shown, my lord, the determination of the learned Chief Justice making the order, my lord, and as to how the cause list was printed on that day. In paragraph 24, it is pertinent to remember that the jurisdiction of the court may be qualified or restricted by a variety of circumstances. That the jurisdiction may have to be considered with reference to value, place, nature, and the subject matter and the age of the case. The power of the court may be exercised within the defined territorial limits. It may be qualified or confined to subject matter or prescribed value. The court may have competence to deal with cases of a specified character, for instance, testamentary or matrimonial, appeals, revision, writs, specified subjects, such a land or service, and so on and so forth. The jurisdiction may be further restricted with reference to the age of the cases. The authority concerned directs the cases tomorrow as to how determination as it is being done. That is the land, it is testamentary suit, like this. It is determined. The classification of the cases. Should I proceed, my lord, with the further reading of this? As usual. Paragraph 25. Against the aforesaid background, let the point in issue be examined in the light of the facts of the case. By the notification issued on March 20, it was determined by the Chief Justice that on and from Monday, March 27, until further order, Justice Bhagavati would sit singly and take part and contempt matters. This determination was operative and effective on April 6. This is apparent even from the cause list for the day. But the division bench was also looking at the cause list as to what the Justice Bhagavati had that determination on that day. What are the cases he has to take? I have taken that pain, my lord, that is why to place before your lordship the cause list.
In the application, you showed us yesterday.
In the application.
Where it is listed at the last.
Yes.
In the last page.
Yes. I've said. This is apparent even from the cause list for the day. On that day, therefore, the learned judge could have heard only parted matters and contempt matters arising out of his own order and none other. And none other. We have looked at the original record of the writ petition out of which the present appeal arises and do not find any direction in the order sheet that the case may be treated as parted. It is therefore difficult to appreciate how the case could have been listed before the learned judge. That is also my question. Within a bracket, contempt of court. Beside the terms in which the interim relief was granted at this stage, the issue of rule in the present case had been quoted earlier. Liberty was thereunder reserved to the respondent in the writ petition to apply for vacating. The proper remedy for the aggrieved such interim order was to move an appropriate bench which was dealing with the said category of cases under the extant determination. With an application to modify or vacate. Yes. There was no question of recalling the said order, and so-called application for recalling the order was thoroughly misconceived. The learned judge therefore could not have entertained the application as such, and determined the subject matter in controversy between the parties and passed any judicial order granting relief in any form in the said order. For the foregoing order, the order under appeal without jurisdiction is and declared to be void. It is clarified that we have not gone into the merits of the dispute, and that this order will not prevent the eighth respondent or any other for seeking an appropriate link with the appropriate bench in accordance with the appeals. No separate order. It is the bench, my lord, who has made the order without determination or is an ascension. I have made an application. This order is to be recalled because it has been made without, because there is no appeal. If it is no order at all, it cannot be seen for any other purpose. So I have made that application, my lord, for recalling the order. Now, my lord, from this, the other judgment, my lord, I would refer to. This is a judgment of 2018. This is a judgment of 2018. Just a moment. For a moment, my lord, dear lordship. No. My lord, let me place not this. I will place, my lord, this order first. Sorry, I'll place, my lord, this order first. This is 1990 Supreme Court. Supreme Court cases. 1991 Supreme Court cases. Sushil Kumar Mehta.
Page
My lord, page 193.
190.
193. Sushil Kumar Mehta. Touch देखिए. Yes. Yes, Sushil Kumar Mehta. It is at page 193. My lord, I will not bother your lordships to go through the entire, my lord, the text of the judgment. It is just a few, my lord. My lord, it has been canvassed that while you have participated.
By consent, jurisdiction cannot be conferred. This is
Pardon, my lord?
this by consent, jurisdiction cannot be created.
Yes.
This was held in this judgment.
If you have participated, now you cannot take. That means you cannot approbate and reprobate. My lord, Sushil Kumar Mehta judgment, my lord, clearly it is said. The defect of jurisdiction cannot be cured by consent or waiver. That is the purpose for which, my lord, I want to refer to. You can ask it 2018, 2018, one Supreme Court case. I'll refer to 2018 one Supreme Court cases. Two 2018 one Supreme Court cases. Page. I've given the copy. Hey, 2018 one Supreme Court cases, page 196. Page 196. This also I will not bother your lordship, my lord, to go through the entire context of the case. It is just, my lord, on the head note it is clear. On the head note, my lord, Constitution of India, Article 145. Constitution of benches and allocation of cases, administrative prerogative of the Chief Justice of India in this regard. Chief Justice is a master of roster, and he alone has prerogative to constitute benches and allocate cases. Any order contrary to present order held ineffective and not binding. Therefore, notwithstanding direction by a two-bench judge, two-bench for constitution of a bench or 5 senior-most judges to decide present matter should be placed before the Chief Justice for constitution of appropriate bench. Principles of law, precedent, judicial decorum demands neither a two-bench nor a three-bench can allocate matter of itself or direct composition of a constitution. Therefore, the supremacy of the Chief Justice is the master of roster of the Supreme Court. My lord, it is held under this, and my lord, it is said why it is necessary. Towards the bottom, there can be no doubt that the Chief Justice of India is the first amongst equals, but definitely he exercises certain administrative powers. The administrative control of the Supreme Court vests in the Chief Justice. And what about the High Court? It vests in the Chief Justice because of the rules framed under the Constitution. It is a constitutional power, according to Justice Desai judgment, and approved. Well, here also it is said, the convention is followed. Why it is followed? The convention is followed because of the principles of law and because of judicial discipline and decorum. Once the Chief Justice is stated to be the master, he alone has the prerogative to constitute. Needless to say, it is that the same thing. But what I am trying to impress upon your lordship, subject opposed to your lordship's approval, that it is the Chief Justice of the High Court is the master of the roster, and he alone can have this. देखा ना 2018 देखा ना चलो well, the last one I wanted to submit before your lordship is, well, it is the 2025 SSC 2025 SSC online SC 582 Garden Shipbuilders and Engineers Limited. In this code, it was the court was sitting upon an appeal preferred under the latest fitting. It was against an order issued under the intercourt appeal filed under clause 15 of the latest patent. Clause 15 of the latest patent. But clause 15 of the latest patent is altogether a different aspect which has no concern insofar as our case is concerned. Yet then, my lord, the court goes to paragraph 8. The cause list of the predecessor division bench dated March 11 would reveal that the determination to hear appeal from order relating to service, Group 6, including applications connected thereto. We have further noticed from the cause list of 16, after September and September 4, that the division bench had the same determination, appeal from order relating to service so and so. Moreover, as per the roster set by the Chief Justice, determination was not given either to the predecessor division bench or to the division bench to hear the writ petition under Service Group 6, appended to the writ rules. We have also noted determination to hear writ petition relating to Group 6 as made by the Chief was given to single benches of the relevant dates. On the face of such determination, neither the predecessor division bench nor the division bench of the High Court could have assumed jurisdiction to hear the writ petition premises on the legal position that they had jurisdiction to hear appeals from order first on the relation. And in this case, my lord, your lordship points in paragraph 9 that Sonlal both has been referred. Sonlal Baid. So, my lord, an order which was made without any determination in the manner the High Court had done, the Supreme Court was pleased with reference to Sonlal Baid. The appeal is accordingly allowed on the opposite terms. So, my lord, concluding my argument, my lord, my submissions rather, concluding my submissions, I will beseech your lordships to kindly consider the prayer with which I have come before your lordship. The prayer I have come before the court that an order has been made without determination. The prayer I have approached the court of the learned Chief Justice sitting with my Lord Justice Bhattacharya, that the order has been made without assignment. This order is completely an ex specie illegal order which cannot remain in the court of records. And the word court of record is not my court, is not my quotation, it is the judicial quotation. It is held that the yes, high courts are court of records, which is established from the Charter Act, right up to the Government of India, extending to Constitution of India. Therefore, in that case, my lord, no question as to what has happened. Let him suffer the ruination. But could there be a tainted record of a High Court? It is a simple question, my lord, my humble question. I am begging of your lordship's kind determination. Now, this is my submission. If any more submissions I have to make, my lord, if your lordship calls up me, I will try to satisfy your lordship. Yes, my lord, I left it for you. These.
Look at the affidavit in opposition file.
The affidavit of affidavit in opposition, the affidavit of Chouradutti Atha, 3rd September 2025. Page 65, last page of the affidavit. When we filed the appeal before the division bench, not taking up contempt matters, in the presence of the applicants here, the respondents in the appeal, the matter was released due to lack of determination. Their lordships felt this bench does not have determination. They did not object, they did not file any appeal or recalling of that. Thereafter, the Chief Justice, as my learned friend rightly points out, the master of the roster, we go before the Honorable Chief Justice. Oh, it's automatically yes. Whatever, go with the Honorable Chief Justice. Kindly come to page 29 of the scan Ford application. Scan 4. The Chief Justice, whether the Chief Justice, master of the roster, did not have the roster to take up the matter. That's the issue here. Whether the master of the roster had the roster on that date. Kindly come to page 29 of the scan. That is the Honorable Chief Justice's division bench's determination. Or she kindly sees in the middle any other matter, irrespective of classification, as directed by the Honorable Chief Justice.
Where is that?
Any other matter, Lordship. I can just have Lordship has got it, Bala. Just below matters relating to contempt of subordinate court, just below that.
Almost,
Any other matter, irrespective of classification, as directed. This is my junior.
almost in the middle of the page.
And
Just
I'm
above,
grateful to my
just
two
above and.
above and. I'm grateful to my two juniors to point this out. Their industry, so any other matter. The Chief Justice's bench, division bench, cannot be said to not have determination.
Not only any other matter, it also says irrespective of.
Irrespective of that. Now the matter comes before the Honorable Chief Justice. Now, the matter, page 35 now, the matter is heard by the Honorable Chief Justice. The matter is heard. No point taken, they are present. They cannot take. With the Honorable Chief Justice, we cannot go and say you don't have determination with that classification. They don't take the point of determination. The matter is heard, interim order is passed. They don't file appeal from this order. They don't file, by appeal I mean Supreme Court, special leave petition, either from Justice Boshak's order or from this order. All the judgments cited by them today are in challenge from that order. Now the matter then comes, so this is the order passed. After 1 year almost, after almost 1 year, the matter is thereafter moved by may I show? Then they feel the necessity for asking for some orders in the pending appeal. And they then move for an interim order. Not a Korea copy, but then may I just hand up to my lord the order copy? কোথায় কোন পেজে বলো না কোন পেজে কি হচ্ছে কি they move an application. I'll give 1 minute. Had a copy? Yes. They move an application. They move can 2 an application before the same division bench. Now, before the bench having determination over the same matters. That is the order of Justice 29th November 2020 in this appeal. At that time, the determination was with the bench presided by Honorable Justice Joy Mallo Bagchi and Honorable Justice Goranka. Order is passed on their application. They don't challenge this order on the ground that I had gone to the court. I am not principles of approbate, reprobate, don't apply to me. I went to the wrong court. I got this order, so challenge. So this order goes against them. And they accept. They don't file any challenge. Now, having tried their luck thrice.
Can 2 was filed by them.
In our appeal, the application filed by them. Now, next comes my lord. So my lord, this is so they try their luck. Justice Boshak releases. They are happy that the matter goes to the Honorable Chief Justice. They try their luck. The order goes against them. They don't challenge. They try their luck once again in November 2024. And now they have the audacity to turn around and make a submission. No proceeding. Turn audacity to make the submission that the Honorable Chief Justice did not have the determination. In the meantime, subsequently, what is this? This is in a writ petition where they wanted a lease to be granted in their favor for this property. These orders are passed. Now, Lordship kindly takes. Lordship, this arises out of this series of orders arise out of an order passed in their writ petition. WPA 15475. The order is at page 36 of the affidavit in opposition. Where they challenge a tender for allotting weighbridges in the port complex. Kindly come to page 40, internal page 5 of the order. That's Mr. So-and-so, last para of page 40. Counsel appearing for the SMPSPMP on the other hand submit that the holiday date 20th November cites in unqualified term that the lease granted to the petitioner also 10 years. However, it is submitted by him that the tender in question does not involve the land sites and 5 numbers of weighbridges for which lease was granted in favor of the petitioner. These are expired. By the impugned tender, the interest of the petitioner will not be hampered, and the SPMP Kolkata shall take necessary action for removal of the petitioner in due process of law. This writ petition remains pending. After this, we institute eviction proceedings before the estate officer. The estate officer passes an eviction order, which is page 46. Eviction order made on 4th of December 2024. From this eviction order, they do not file appeal under the Public Premises Act, or they file appeal, they don't get a stay. Or they don't file appeal. They did not file any appeal. They come up in writ petition. Writ petition is dismissed by an order which is at page 9 by this honorable court, page 9. Writ petition is dismissed. Well, I will just take 2 minutes and I shall finish it all. I don't want to glorify this case by making any further submissions. Page 9 is the honorable single bench's order dismissing the writ petition. Thereafter, we take possession of the property. Then they file appeal from the order, which is at page 22. The appellate court's order, 23rd April 25. The appeal is dismissed. And Lordship kindly comes to page 33. Page 33. That's last page of the order at 33, paragraph 26. Page 33, the learned single judge, while dismissing the writ petition, granted liberty to the appellant to prefer statutory appeal. Since the time given by the said order has already expired, we extend the time to prefer the appeal for a period of 12 days. No appeal filed. Paragraph 26, page 33. No appeal filed. So this matter has been brought to rest. Instead, they go to Supreme Court. Page 34, Supreme Court dismisses their sin on 18th August. Thereafter, they hatch a brilliant plan to undo everything by saying that the allied proceeding, Honorable Chief Justice did not have determination. And because Justice Joy Sengupta sitting in a single bench had referred to that order, if this goes, everything will go up to Supreme Court. It is an infructuous proceeding. They have filed this application to abuse the process. Well, I have nothing. Lordship is rising. Lordship kindly allows my junior to just deal with their judgments, if at all necessary. But then, or I will just finish. Lordship, I was going through their judgments. Lordship kindly sees one of the judgments at 2007 Supreme Court, 2008, 18, 18-1 SCC, page 196, as cited by them. I just want to show one sentence from this order. এটা কপি তুমি ওরা দেখিয়েছে ওরা মনোপত্র দেখিয়েছে মনোপত্র দেখাও তো মানে we could get a manupatra printout of that, this judgment 18-1 SCC. Well, may I hand up, this is get given the SCC printout. 18-1 SCC, page 196. paragraph 6. There can be paragraph 6.
So it is the same in both the printouts.
I want to show that the Chief Justice can never have non-determination. Cannot be said he is the master of the roster. Paragraph 6 and 7. Paragraph 7, I am just showing we have to make it clear without any kind of hesitation that the convention is followed because of the principles of law and because of judicial discipline and decorum. Once the Chief Justice is stated to be the master of the roster, he alone has the prerogative to constitute benches. That includes his bench also. Middle of paragraph 7. Needless to say, neither a two-judge bench nor a three-judge bench can allocate the matter to themselves or direct the composition for constitution. To elaborate, there cannot be any direction to the Chief Justice as to who shall be sitting on the bench or who shall take up. So his lordship has taken it up. Even if this line was not there in the middle of that page, he could have the honorable Chief could have taken up any matter because he has determination. His lordship has determination to hear any matter. So that is really all. Paragraph 10, there will be judicial anarchy if the Chief Justice can't decide who will hear what matter. Well, I have nothing more to add. I have not cited any new judgment, so I suppose they will have no right of return. I'm very grateful to him. Sorry.
Should I, my lord?
I am.
My lord, this is at page 29, perhaps, in my application. Yes. At page 29 of my application. That is the brilliance of a good advocacy or a bad advocacy. I must appreciate it. Lordship kindly goes to page 29. Any other matter irrespective of classification. My learned friend, stop there. Any other matter irrespective of classification. There are many more things in heaven and earth than it. That is what is dreamt in our everyday life in Hamlet. Yes. How it is read? Any other matter irrespective of classification, comma, as directed by Honorable Chief Justice. Show the direction. That this was determined. Show the direction here. Show the direction. Even if I am a very crafty lawyer, I would take your lordships to page 34. Page 34. For admission, what is admission? For admission, criminal appeal. Is it a criminal appeal? It is a contempt appeal. Then Matt. Was it the direction of the Chief Justice? Well, I am the last person to consider that my Chief Justice was that fool. That in this manner the direction was made. My Chief Justice was not that fool. Maybe we are fools here. Contempt appeal. Is it a contempt appeal? Matt. What is Matt? According to your বইটা দাও? No, এটা না, পাতলা বইটা।
Well, let me clarify just one line, my lord, if lordship allow me to.
1001 clarification.
One line.
My learned friend has pondered over what the Chief Justice, what the division bench has said, what Justice Joy Gupta Sengupta, what Justice Joy Mallo Bakshi. Joy Mallo Bakshi is not before this court. It is in that court.
But may I just utter one line before your
Yes.
lordship to clear?
Please.
My lord, in the order passed by my lord Justice Roy, it's a final order disposing their application for contempt. Now the unique thing in the order was that his lordship did not find us guilty of contempt, but passed an order. Now, my lord, a confusion was created. If his lordship has not found us guilty of contempt, how can an order be passed? So, my lord, we advise that see as although it is in a contempt jurisdiction, although it is in the contempt jurisdiction, we were not found guilty as contempt. Let file a normal appeal because we were not found guilty in the order. So that is why that was termed as MAT, which my lord Justice Boshak's division bench thought no, it should be contempt.
That is
So
not,
the-
that is not an issue. He is only confined on the issue of determination, nothing else.
that we have accepted.
He has not said anything about anything else. In fact, he says we should not travel beyond that.
That my lord we have already. I am grateful to you, lordship.
Anything else?
No, madam. Madam,
Huh?
I express my gratitude to both of you. Much
Heard
enough
me?
time has been given to me.
Heard, learned
Lordship. Judgment को पूरा बैग लेकर वो फाइल यहाँ पर ला सकते Lordship.
On the previous occasion, Your Lordship. Yes, the affidavit in reply to the reply to the affidavit in opposition which was filed before the Honorable Single Bench, that has been preferred, but subject to condition that this affidavit in reply was not relied during the course of proceeding before the single bench. Lordship.
Relied, not relied, that comes later. The point
Lordship.
is, if it is part of the record, then it should be part of it.
Lordship. So I've gone through the records, Lordship, and I have been instructed by the department is that in this matter I'll be led by learned Deputy Solicitor General. So
Then we'll keep it other side of the holidays.
Lordship, because since learned Deputy Solicitor
You argued everything, now you want to be represented by a learned.
Lordship, that is the wish of the department, Lordship.
But now your argument is over, now they were to make submission.
Lordship.
Anyway, if he wants to be here, we can allow him to be here. But your submission on your part is complete.
Lordship, my submissions has been completed. So far in respect of supporting my contentions, I have also placed certain judgments. That is BC Chaturvedi's judgment I have referred, P. Gunasekaran, and thereafter one judgment, a very recent judgment passed by the coordinate bench of this honorable court that has been relied, which specifically stipulates that the order of discipline so far in respect of the civilian post and the paramilitary forces are completely notches above, at least not at par. So
When to have it?
I'm ready.
subject to your Lordship convenience, can this be accommodated after 1st of November, Lordship? I mean, any date after 1st of November, Lordship, subject to your
Date,
Lordship.
why don't you give a agreed date? So that once we say, then you will say, no, not this date, this date. So therefore, we
Well,
are-
so far, my learned friend's submission is concerned that he desired to gone through the affidavit in reply. If there is any contrary to his submissions, he can add. My lord, we are waiting, and as per your lordships, after hearing his submissions, at least 8 or 10 days, your lordship time given to my learned friend and fix it 2 days. My lord, I am waiting for my chance that if there is any contrary submissions coming from my learned friend's part, then I shall only question of law can argue before lordship.
So therefore, he says he wants to, he is under instructions that the DSG has to appear.
Lord, if he desires so, my lord, subject to kind sanction.
So, but then we must have a convenient date. That is why we are asking.
After 1st, any date of your convenience?
Lord, I am suffering an order of dismissal. And I was, my lord, out of service since long. And after getting a reasonable order from the trial court, my lord, they preferred an appeal. My contem was pending. My lord, I have not been allowed to resume. I am not getting a single penny. I am a discipline. I am a member of a discipline force. I am fighting for my survival, right to livelihood. Well, I have nothing. And in this way, my lord, if the matter was, my lord, delayed, subject to kind sanction, you will have ample opportunity given to us. So kindly consider and finish this matter so that, my lord, rightly, wrongly, whatever lordship feels, had there been any occasions to interfere this order passed by the trial court, your lordship pass it. But this matter should be kindly consider. Because so far my learned friend party's concern has already been completed. Now my turn.
In the trial court's order, which portion my learned friend aggrieved? What documentary evidence has not been considered by the trial court despite placing my learned friend during the inquiry proceeding? My case, that the proceeding was proceeded with the matter with no evidence. And it is a perverse findings. On the basis of that, the trial court taking into consideration the entire documentary evidence and pass a reason order. And on the basis of that, my lord, I am waiting that I should be considered by the authority or allow me to resume my duty. I have filed a contempt application. That contempt application was pending. In the meantime, my lord, they come up with the appeal.
What is the date of the trial court's order?
My lord, trial court's order,
That was August 28, 2023, Lordship.
Why the appeal has been filed in 25?
No, this was filed in 23, Lordship. Appeal was filed. This was filed on 13th of December 2023, Lordship. This appeal, Lordship, subject to Lordship kind sanction, this appeal has travelled two coordinated benches before being heard by your Lordships.
No, but this why?
No occasion, Lordship, there has been any delay whatsoever has been caused by the appellant, Lordship. Now, so far in respect of this affidavit in reply, which has been kind of a genesis which has been made by my esteemed senior friend. Now, Lordship, kindly appreciate this piece of document was never served upon the counsel representing the respondent's appellant, Lordship.
Lord,
In the tribunal?
Before the single bench.
I disagree.
Before the single bench, this reply, the affidavit in reply
Was not served.
was not served.
No, my lord,
I consciously can
So
take
we had
this,
asked you to take instructions to it. You have not said anything.
Lordship, on the previous occasion, your Lordship has directed to produce a single piece of document where from it reflects that this affidavit in reply was served upon me. My esteemed senior friend on the next date mentioned that from the bar, it is understandable that sometimes we take up.
That it is part of the record is obvious because it is a certified
It is a certified copy, Lordship. I am not denying that.
So therefore,
But it is absolutely, it is also evident.
for us.
My lord, it is the case of my learned friend. That appeal should be filed annexing all the copy of
Why have you not filed any affidavit? Why are you making oral submissions that it was not served or anything like
Lordship, there hasn't been there were no affidavit in reply served upon us during the course of hearing before the Honorable Single Judge, Lordship. Kindly appreciate, Lordship, this affidavit in reply, which has been now served upon me in pursuant of your Lordship's order, that has been notarized on 6th of January 2023. And thereafter, the single bench,
We
Vide
had
order dated,
adjourned it on 8th of September.
Lordship.
In the meantime, why did you not place this stand on record, which you are making orally today? Can't just be prolonged like this because you stand up and say something. Therefore, He is giving a certified copy. It's part of the record.
Lordship, that is,
There's nothing before us to say that it was not served on you.
Lordship,
And we allowed you time.
Lordship, kindly appreciate one thing. Lordship, on the previous occasion, your Lordships had directed my esteemed senior friend to produce any document for where
What is that order? Show us, please read that order. The last order is of 8th September. Now read where we have said in 8th September order to produce any sheet of paper.
Just allow me a Lordship, 8th September, your Lordship has directed that the matter should be Current counsel for the respondent, however, submits that the reply filed before the Honorable Single Judge is not forming a part of records in the present appeal, which is proposes to bring on record. Now, thereafter, your Lordships has also opined that if that's I at the very threshold only, Lordship,
When you make a submission regarding the court's order, we expect some responsibility
absolutely
when you make such a submission. A submission regarding a record which is not there, being made by a counsel who was there in the court, and the order has been passed on 8/9. It is not that it was passed yesterday that you don't know about the order.
absolutely.
Why do you make such a submission? You have no responsibility.
Lordship, I completely bow down before your Lordship.
No, it's not a question of bowing down. It's a question of being a responsible officer of the court. Therefore, we asked you to read this order. That we have directed them to produce any sheet of paper to show. Where is that direction? All in your mind. That's very unfortunate circumstance. A lawyer who has been appearing in this matter for the last 3-4 days. All orders are passed in your presence. The order has been uploaded long back and you are making this submission.
I completely bow down, Lordship. I tender my apologies, Lordship.
This is not expected. This is not expected.
Lordship, kindly appreciate on the fact that
What appreciate? When you make such submissions and then you say appreciate. We are looking at the way you are conducting the proceedings.
Lordship,
You have no responsibility for anything you say to the court. You are reading something into an order which is not there. This is not expected and not appreciated at all.
I tender my sincere apologies, Lordship. Lordship,
So everything we have to ask you to read, or we should be able to rely on what a counsel says. A small order of 8/9/2025, and you are making submissions which are contrary to the record. And when you repeated it thrice, then I asked you to read. We don't appreciate this at all. This is not expected from any advocate. One may commit an error. This is not an error. You said it once, twice, thrice. It's not there, sir. We had adjourned it because we have noted that he is giving a certified copy. Therefore, we're taking it on record. There can be no dispute that it forms part of the record. We adjourned it because you said that let me verify whether it was served or not. Today, you are standing up to say that now DSG has to appear. So you have not verified whether it was served or not?
Lordship, that was not served upon. That was to be ensured by him, not me, Lordship. That if he serves something on me, there has to be an endorsement with him.
All right, then how you are saying it was not served?
Lordship, they were.
How are you saying it was not served then?
Lordship, kindly direct my.
If it is all to be said by him,
single document,
he
Lordship.
is the person who has to say whether it was served or not, then how you are saying it was not served?
Because I was the counsel.
Very-
I was the counsel who appeared before the single bench.
And now
I
again, still
consciously-
you are saying that you don't know whether it was served or not. He has to say.
Lordship, I completely, Lordship, I am aware of the fact. That is why I'm saying unconsciously that this affidavit in reply was not served to me when before the single bench. Let him produce a single
stopped-
document, Lordship.
Who stopped you from making this statement? Who stopped you? And why did we adjourn the matter for such a long time? For you to stand up and start arguing the same thing again? You have not filed any affidavit, so we will not accept this submission. In fact, we can reject it right now. In spite of an opportunity, you have not said anything about service or non-service. Why should we allow you to make an oral submission like this? When we have recorded that it forms part of the record and you think it will be taken without service in the writ proceedings.
Lordship, this was filed with the department, Lordship.
Everything is in your head, sir. We don't know.
Lordship, this
Either you are saying we have to verify all these things or take it for what you are saying.
Lordship, kindly appreciate on
What appreciate? What kind of stand you are taking?
Lordship, the order dated 27th of July 2022, Lordship, before the coordinate bench on the while the writ petition was pending. The coordinate bench, the Honorable Single Judge has recorded in its order that till 23rd June 2022, no affidavit was filed. On that very day, I was the counsel who had filed the affidavit in opposition before the single bench, Lordship. That has been recorded. And thereafter, it was recorded that despite service, there hasn't been any prayer for extension of affidavit in reply being made therein. Thereafter, this affidavit in reply was affirmed on 6th of January 2023, Lordship.
All right, you proceed.
Lordship, may I indicate one thing, Lordship? Thereafter, Lordship, by an order dated 20th of July 2023.
Sorry, sir. You got the opportunity. You have not filed anything. You proceed.
Okay.
We'll record that in spite of opportunity, you have not disputed this filing of this before the single bench. This is not the way to proceed in a judicial proceeding. Yes.
My lord, my first link of submission before lordship that trial court has passed an order discussing the entire matter, fact of the case, relevant documents which has been relied by the parties, and pass an order in favor of the charge officials. My lord, if your lordship allow me to just read the relevant operative portions of the judgment. My lord, should I read, lordship?
Of?
of the judgment passed by the trial court.
Yes.
My lord, the judgment at page 289 of the stay application, which has been filed by my learned friend.
Yes, 289. We have 289.
Your lordship got the
Yes.
lordship. My lord, the judgment consisting of the total 47 paragraph. Just I'm relying out of 47 paragraph, few paragraphs, and thereafter the penultimate paragraph, which has been disposed of this case. My lord, here if your lordship take trouble to the page 290, paragraph 2. Well, my contention, well, I'm reading this one. The fact required to be adumbrated for the purpose of effective adjudications of the writ petitions are the petitioner joined as a constable in the Central Industrial Security Post, in short, CISF, on 20th August 2010. On 4th October 2013, he has been posted as constable in B timing 13 hours to 21 hours under A company at the tunnel gate of ISCO ISP Burnpur, West Bengal. One R.N. Upadhyay, head constable, and one Muhammad Alam, assistant sub-inspector, were also posted in the tunnel gate from 13 hours to 21 hours. One Harambir Kadam, sub-inspector XC, was in charge of the monitoring security checking at the gate through CCTV camera. The lordship searching any documents, my lord, may I assist lordship?
Just give us. Yes. Which page?
So I'm
289.
no 290, paragraph 2 of the judgment, lordship.
No, we have gone through the order. Why?
I told you,
why
relevant
placing-
portion. I'm
Yes.
relevant portion, my lord.
Yes.
Just I assist your lordship in a manner that is security tunnel, which has been through the gate, the letting in the vehicles, those are coming from outside to inside. My
Yes.
lord, a consisting of 4-man persons, they are in the mentioning in the judgment, paragraph 2. Now, my lord,
See, the judgment is what is impugned in the present proceedings.
lordship, I got your lordship's point. So for the formation of a team, it would appear from the page
Yes.
60, just a moment. My lord, page 97, if your lordship. Page 97.
If we remember correctly, his entire submission is hinging on the deposition of the man who was manning the CCTV. He has deposed in the inquiry.
Lordship, correct.
So that is the only issue. Let us see what you have to say.
My lord, according to my
Because there were three witnesses.
three witness.
Two, of course, you have said, or this honorable single judge has found that they were doubtful for whatever reasons.
Lordship.
The third one is the one who was manning the CCTV in the CCTV room.
Lordship.
He has appeared, he has produced the CCTV footage and he has said that yes. So let us see where is that deposition.
Lord, before coming to this, I try to assist your lordship in
Yes.
a manner that in the tunnel, security gate or tunnel, they consisting of the formation of a security team. Your lordship, kindly come to the page 97 once.
Yes, we are at 97.
97. My lord, here, my lord, the strength, one sub-inspector, oblique ASI, 3, 1 each shift, A, B, C, my lord, or my lord, the shift A, my lord, mentioned in time, in the last paragraph, paragraph number 7. My lord, thereafter, 1 head constable, 6.
At page 97.
Yes. Page 97. Inner page 66.
One head constable GD, one constable
Lordship.
is to be deployed there.
Deployed, Lordship.
Yes.
So, my lord, assuming any vehicle which is coming through outside, your lordship, kindly.
So this one constable GD and one constable is in the inside.
Inside. I was inside.
And outside?
Outside, my lord, 1 sub-inspector, 1 head constable, and 1 constable. 3. And 1 only myself inside.
No,
and another.
There are 2 inside, not 1 inside.
Yes. Is shift, 2 in 1 shift. But here, and 1 Kadam, he is monitoring the security through sitting in the, my lord, CCTV room.
Yes.
My lord, this is the formation of the team. My lord, so far the eyewitness is concerned, those are, my lord, the member of the team. If any vehicle was passing through the tunnel gate without checking passed properly, my lord, initially first it has been detected by the outside officers, those are, my lord, at the SI, sub-inspector and head constable. Thereafter, my lord, they let in the vehicle inside after observing all the formalities and checking. Thereafter, it has been inside. I was waiting in the inside. What is the allegation against me? According to the charge, I have given permission to the vehicle shown in the CCTV in the plant. Well, how could I give the permission? I have no occasions to be because the entire formality had to be observed by the other officials. Those are the member of the team leading by the sub-inspector or the ASI. So after observing all the paraphernalia, all the procedural things, thereafter the security personnel allow the vehicle to inside into premises.
Yes.
When the observations and the security checks are complete, then only the gate is open and the vehicle was coming.
Yes.
And thereafter, the vehicle was inside the premises. So I have given the permission, this is the charge, or I have been allow the vehicle to be get entered in the premises. These are not correct. This is totally vague. So for the
So
prosecution,
you were there for no purpose.
no, Lordship.
You were there for no purpose.
No, I was to follow the instruction of the higher officials. Those are complete the formalities and let in into the vehicle inside. I'm seeing how many persons, whether they're coming through or there is any other thing.
What thing? That's what we
Because-
are asking. You are saying everything was to be done by these two persons outside.
Correct.
So you were just standing there. You had no duty to conduct or to perform there.
No, my lord. What
You are
happened, my lord?
just a ceremonial person standing there.
So for the allegation,
Where is this duty defined? When did you place this before the inquiry officer or the person who was going into the charges that, look, this is the allocation of duty and this duty is not assigned to me. Whatever has to be done outside the tunnel. Those 2 or 3 persons are standing there. They have allowed him to come. I just had to open the gate. Where is this? Let us see.
I try to assess your lordship. For your lordship's query is concerned.
No, but you are making a submission. Show us the factual foundation for this submission. That we are asking you. You have already submitted. This we have now seen. Now show us the factual foundation.
Lordship.
Where have you taken this stand and based on which duty assignment have you taken this stand? Show us.
My lord,
We will not presume that a team of 5 persons are posted at the gate and 2 are just standing there for no purpose. Unless there is a duty assignment allocation which says that yes, this is how these 5 persons are to be allocated, 3 outside, 2 inside. The outside persons are responsible for everything. The inside person has to conduct duty inside. Only entry vehicles, he opens the gate.
correct. My lord, to that aspect, my lord, my humble submission before lordship, very simple, that
No, we don't want an answer from you. We want you to show from the records.
I tried.
Either the duty allocation, if it is specified anywhere in any rule regulation or circular or whatever it is, a general direction issued by the person in charge of the facility, and whether you have taken this stand before the inquiry. If not, then how can you argue these things? Show us from the inquiry where you have said this.
Lordship. Now,
We are not sitting as an appellate authority that we will go into the charges again. We are to confine ourselves to the procedural aspect. You are asking us to go into the inquiry.
my contention before lordship,
We have understood, sir. Show us from the
Yes.
record. Don't repeat.
lordship. Your lordship kindly come to the
Where is this duty allocation? Where is the assignment of responsibility of the person?
this stay application has been filed, my learned friend, taking into considerations that all the documentary evidence has been annexed. Only a rejoinder was not. I am just placing before lordship. So the documents which are in the stay application, these are the complete set of the documents except the reply. And I try to assess your lordship from the bunch of the paper which has been coming.
That's what we are asking you. Show us.
I try to. I try to. Lord, here. My lord, my statement before the inquiry officer, if your lordship take trouble to the page 149, defense statement. So for the lordship's queries, standard operating procedure in respect of the my lord, allocation of the job, allocation of the duties and others parameters is concerned, my lord, what your lordship asks me, that has not been given to me any copy. My learned friend have the copy, they can place before lordship. But I took this point in paragraph 12 of my reply. Your lordship got 149.
Yes. No, that is not your stand. Your stand is you conducted the security check.
Pardon, lordship?
Your stand in the inquiry is that you conducted the security check. Quite contrary to what you are submitting. You read page 149.
Lordship.
Sir, all persons, vehicles that entered the plant during my duty hours were allowed entry by me after I conducted the security check. This is your stand before the proceedings. Here you are saying it was not your duty.
I try to assess your lordship that the allocation of the duty.
All right, that is your stand. You cannot shift from this stand.
Now, if your lordship take trouble to the paragraph 12 of my reply, which has
What
been.
reply? We'll go by this. You may have filed any reply. We are here to see whether there was any infirmity in the inquiry.
Correct.
You are bound by the stand you have taken before them. You cannot be allowed to shift or change that stand by filing a reply in a writ proceeding or an appeal proceeding. We will not allow you. This is your stand.
So far, what are the allegation against me? The allegation that.
Where is the charge memo? Which page?
Lordship. Page
86.
86. Lordship.
The charge is that you did not check this vehicle. That is the charge.
Lord, charge. Just only.
Page 87. Come to
87.
Yes.
Ravi Kumar, while performing duty in BSIF on 4/10/2013 from 13 to 21 hours at Tunnel Gate, did not check the entry of a light motor vehicle bearing registration number such and such, and the vehicle got entry into the plant premises at about 1858 without security checkup, including checking the entry pass permission of the said vehicle as well as its occupants. As a result, which miscreant who were in the above vehicle gained access into the plant premises and later apprehended by the CIW personnel of the unit while they were attempting theft of plant property such an act of the part of the Constable Ravi Kumar tantamounts to the gross misconduct, dereliction of duty, and violation of the lawful instruction. Well, here, the allegation that I have been not checked the properly got entry the vehicles in the plant premises and not also checking the entry pass and permission of the said vehicle. My contention before Lordship with regard to the charge number 1 is concerned that all are the formality of the outside of the gate, where sub-inspector, ASI and the head constable are deported by the higher officials for a combined team. If they allow the vehicle to get inside the vehicle, Malud, and I try to find out that the vehicle is Malud, within the control of the speed limit, whether they are stopping the vehicle in any elsewhere. Or they have to stand the vehicles in the not parking zone or not. Now thereafter, Lordship, the prosecution witnesses, those are the main witnesses in respect of the departmental proceedings, in where, my lord, if your lordship take trouble to the contentions of the Ramnath and Sunil Rai, they are the eyewitness. They never make any allegation against me or not given any depositions against me. If your lordship take trouble to the page 99, but it is the English version 101. Ramnath.
They are not eyewitnesses.
My lord, he is the prosecution witness number 1.
You said he is eyewitness. He is not eyewitness.
My lord,
he is member of the party who has found the vehicle inside the premises.
lordship, stand
He is
corrected.
not an eyewitness.
Stand corrected.
Everything you are submitting contrary to the record.
Second part is, my lord, the
Both the witnesses who you are
Sunil Rai.
referring,
Sunil Rai.
both have seen the vehicle inside.
Lordship.
Neither of them are eyewitness.
Lordship. Now,
Therefore, we said there is only one witness who is relevant, who says he has seen this incident on a CCTV. Kadam, where is his deposition?
lordship. Now, so far the Kadam part is concerned,
At page 114.
if your lordship take trouble to the page 1115. 115, lordship. So, page 115, my lord, it appears, well, I need not to be, my lord, just read the contention. Only, my lord, just assisting your lordships, my lord, that only mentioning that one sentry. Lordship, 123 again, your lordship.
Come to 117.
Lordship. My lord, 116. The deposition of the Dharambir Kadam completed and the inquiry officers, my lord, allow him to cross examinations of the same which was been declined by the charge official. So far 117 is concerned, my lord, kindly.
Sir, that is of 2711.
Lordship.
His deposition has not finished. His
Maybe
deposition
continue.
continued
Maybe
on
continue next.
2811.
Maybe.
Now
I
see
don't-
what may be. This is the record. Read
Lordship.
page 117.
Lordship.
You're
My
not-
lord, I am requesting your lordship, kindly come to the 118. Is the English version, my lord? He has. কন্টিনিউ করবো, শেষ করে দেবো। So for the Kadam deposition is concerned, only question number 2, my name has been pronounced. But so far the CCTV evidence is concerned, question number 3, but he admitted himself that in the video footage, Constable Rovicul is not seen in doing. He is answering question number 3. Lordship.
Was waiting outside. Before entering the tunnel, the vehicle was waiting over the
But
45 seconds.
before entering, because I was not at the gate of entering, I was the inside. And my lord, Bullshit.
For judgment item number 1.
My lord, the continuing matter, my lord, will take it after this one. The matter which was continuing, Lordship, I apologize, my lord. Item number 4 was continuing. After. I'm waiting, Lordship.
Matter item number 5. Can we, before we proceed any further, actually, both of you were reading one line from here and there. We'd like to see the reply filed before the tribunal.
Yes.
Just let us see the reply
Yes,
first.
because I was going to rely upon my lord's own judgment. The same point.
All right,
Whether they have dealt with in the reply or not.
let's see. There's some judgment delivered by this bench.
Yes, yes. Yes, this bench. This is in Lord WPCT 204 of 2024. I'll take a copy that.
So the mind is working in the same way. I don't remember these judgments. I have a very short memory.
My junior helped me with this judgment. I said, this is good enough for us. Paragraph 23.
This is of last year. Paragraph 18.
23.
This arises out of a transfer matter.
No, that issue was not transferred. It is transferred. That issue was related to the scope of teaching.
This is also arising out of transfer.
Transfer. Yes, this was transferred.
Let's see the reply first.
Yes. The reply to that.
269, no? It starts from 269 reply. How can you put it?
No, 269 is the applicant's rejoinder.
Rejoin. 210.
210.
210.
210.
210. 210. Lordship may please to come to play 211 paragraph 5 II. State, yes. And then we'll at page 213, Roman 4. Except ball denial, Miller, they did not produce the records. Nothing is annexed. That is not ইস্যুটা কি বলবো যে আমাদের ওই অ্যালিগেশনকে ওরা কি কন্ট্রোভার্ট করেছে
My lord, will you also please to see the affidavit filed by the gentleman who admittedly is the secretary of the other association. He says so. And page 225, my lord, reveals something more. Here he says, may I read it, Lord? Page 225, down the middle, it is a fact that I am the working president of the Paschim Bongo Rajya Sarkari Karmachari Federation, director of MSME, the applicant herein who claiming himself as general manager, general secretary, rival association, so and so. Then according to me, it's very important. The documents in the instant application at page such and such out of the aforesaid documents, page 87 being annexure P7, page 90, 91 being annexure P9 were not received by the office of the director of MSME. The documents are totally false and fabricated. How did he know that it was not received by the director? And how could he say these are false and fabricated without producing the file?
And at which page is your specific
Page
assertion?
273. Page 273, paragraph XX. Applicant states that the entire note sheets files from 29 July 24 relating to detailed processing and arriving at the decision of the transfer order is produced and copy of the same is handed over to the petitioner. Petitioner shall suffer irreparable loss and injury. This was the specific statement before the tribunal. And Roman 19 also.
Where are these documents? This document that is referred in XX.
Yes, yes. This is the document, my lord, in the note sheet of the department that was refused even under RTI.
That was not given.
They say for larger public interest. Now that if it is a larger public interest, court is entitled to look into it. But can there be any larger public interest in case of a transfer that itself will not gives me not some smell of malafide? দিয়েছি ভিত্তিতে আলোচনা করছি
That's all.
That's all.
And which paragraph of this judgment you are relying?
The paragraph 23 specifically. That this court was kind enough to deal with the necessity of pleading, and if something is pleaded and not document disclosed, then the court was taking an adverse view. Insofar as submissions of learned senior advocate appearing for the applicants regarding violation of Rule 12 of the rules, we find Rule 12(1) contemplates the filing of a reply by the respondent intending to contest the application. Sub-Rule 2 contains the procedure to be followed at the time of filing of reply under Sub-Rule 1. The respondent is given an opportunity.
Reading paragraph 23.
23 of the judgment milot of WPCT 204.
You've given us some different judgment.
এরে কি দিয়েছো কি করো না দেখে দাও আবার তাড়াহুড়ো করো না
204
এটা অন্য জিনিস দিয়েছো আরে এই জজ সাহেবের হতে পারতো জজ সাহেব তো অনেক জাজমেন্ট দিচ্ছে
204 টা বলছেন
হ্যাঁ যে তোকে দিলাম
It's not reported, then give them. If it is not reported, then give them copies.
I'll give you a copy. এটা 204 ওটা
We
কি
got two
দিয়েছেন
copies.
জাস্ট ভট্টাচার্যকে তাই দিয়েছেন
We have got two. 204. We have got.
paragraph 20 down the middle. However, the respondent, while filing their reply, have chosen not to place on record the advice of the vigilance. Though it was the case of the respondents that the panel dated so and so was cancelled based on vigilance advice.
So yes, this is recently we have 10th September, recently. It was recently delivered.
Yes, yes, very recently.
In this case also, Mr. Majum, he was appearing, yes.
He had assisted me by showing this judgment. I said, then we don't have to travel for other judgments.
Then we'll hear them if that is all.
Yes.
Yes, please.
First of all, Lord, yesterday I wanted to draw your lordship's attention that the documents which has been annexed, page 117, no? 117.
May I take leave?
Please, yes.
117.
Yes, you were reading from the affidavit filed by the respondent number 6.
Yes, 117 নয় তো এটা 213. I'm sorry. ডকুমেন্টটা বলছিলাম যে ডকুমেন্টটা ওরা No, that is ডকুমেন্টটার কথা বলছি. The document what I have shown to your lordship that they have relied upon that
117.
117, no, not 117.
117 is some different
No,
document.
no, that is not 117. In compilation, they have 151 H. But this is the document, Lord. In compilation,
In the compilation, which page?
the third page. Annexure A, third page.
Which page?
Third page.
In compilation. A.
A. Is in the 151. It is 151, your lordship will find from the brief. Your lordship's brief.
Yes.
151. 30th
So
July,
regarding this, you were reading from his reply.
yes, 30th
that it
July
is,
2024. Blood, this is the, according to us, but we have stated in the reply also.
No, you have not stated. You are reading from his reply.
No, we have also.
That
we have-
statement that it is
No,
false
we
and
have-
fabricated, you
have
were reading from his reply.
No. Our reply also we have stated.
Where is that? Let us see.
Blood. এক মিনিট দাঁড়াও, hold on.
Yesterday you had placed from his reply.
213.
Yes.
213. Blood, the applicant has to make strict proof thereof, otherwise it will be presumed that they said later
So
that
there
30th
is-
July is a false
All
and
right.
fabricated document.
This you had read from his
No.
affidavit yesterday where he has said that it is
It
false
our
and
affidavit,
fabricated.
my lord. Lordship, kindly see. Blood, 209. 209. Starts from 209. 2010 reply on behalf of the state respondents.
No, in his reply, he has specifically stated that it is false and fabricated.
We have also.
No, you say it is
210,
presumed. It is
210,
presumed.
210. Blood, it is our case and there is no denial. There is no denial.
210.
210 blood our starts. This is the starting blood of our reply application.
Yes.
Reply on behalf of the state respondents.
Yes.
And Lord, only 2 or 3 things, Lord, I will submit before you.
Please, yes.
But number one, your lordship has specifically asked, is there any impediment, legal impediment and the rules? Yes, he cannot be transferred. But candidly, my learned senior friend has said, though there is no legal impediment or something like that, but there is a smell because these documents we have asked for, that was not supplied. But I can show to your lordships from the writ petition and appeal petition is not with me. My lord, they have taken several my lord, measures to stall the my lord, the transfer order. In the writ petition, my lord, they have come up, my lord, I have submitted yesterday before your lordship. The last day of expiry, they have applied under RTI, but there is a stipulated period. But before expiry of that, they filed the writ petition. And on the last day of expiry, my lord, we have supplied the documents which are available or which are not and my lord, which cannot be supplied. We have said so. My lord, that thereafter, my lord, the land single judge has asked us to produce the documents. Against that, my lord, we have filed the appeal before the Honorable Division Bench, coordinate bench before the Honorable Division Bench. If I show to your lordship the Honorable Division Bench order, there is a clear admission from the petitioner. কোথায় অর্ডারটা কোথায় গেল? Order Division Bench order কোথায় গেল? Petitioner, they have also filed in the compilation. আমাদের কম্পাইলেশনটা গেল কোথায়? না নিজে রেকর্ড দিচ্ছি। Blood.
You are saying single judge it?
Land single judge thereafter will dispose of the matter. No. After the Honorable Division Bench order, the land single judge has disposed of that order also with before your lordship. But if your lordship kindly see from the starting, Lord, I am reading. Appeal is at the behest of Article 12 authority and directed against an order dated 9 July 2025 passed in WA number 13305 of 2025. After elaborate hearing of both the sides, learned advocate appearing for the writ petitioner's private respondent on instruction, the writ petitioner private respondent number 1, who is present in court, submits that the impugned order may be set aside since the writ petitioner's private respondent intend to prefer an appeal challenging the appellate authority's order dated July 10, 2025. So we find from the record that the two applications under the Right to Information Act 2005 were filed on May 19, 2025 and May 23, 2025 on refusal of the concerned officer to grant the information sought for. Well, this was the submission of my land senior friend. An appeal was preferred. Appellate authority under the Act of 2005 passed an order dated July 10, 2025. Private respondents are aggrieved by non-grant of all the information sought for by the appellate authority. Subsequent to the order of the appellate authority being passed, the petitioner's private respondent seeks to assail such order of the appellate authority before the appropriate forum. Lordship kindly mark it. Such stand of the petitioner's private respondents being reasonable is accepted. Order impugned is set aside. The petitioner private respondent may assail the order dated July. My lord, how, my lord, the said submission can be asked before your lordship. Again, when they have stated, yes, we shall file the revision before the after the appellate authority's order, and thereafter, if your lordship kindly see,
Is this order on record in these proceedings?
but they have in these proceedings, I do not.
Page 166.
In the petition, they have stated
166.
yes, and lord, thereafter.
Then we don't need this.
The other things, Lord, they have filed the compilation against that, Lord. We have filed this, Lord. It is.
What else do
helpful?
What else do you want to show from?
But your lordship kindly see, we have stated compilation উপরটা কোথায়? উপরের ফর্মটা কোথায় যেটা? Lord, details is there, Lord. Lord, 30th July, reply and shortlist details. Lord, your lordship will find what are the documents, what are the actual reason. Let thereafter, writ petition was disposed of because the single judge has said no, nothing remains because Honorable Appeal Court has passed the order or go for appeal. But my responsible submission is this: since the condition of service and 11 years he is in headquarters and he is the industrial development officer. There, my lord, where he has transferred, there is, my lord, 6 posts are vacant, industrial development officer. Out of 26, out of 26, he is the general transfer. Out of 26, 25 persons have joined their post. Then what is the reason? But one after another, his wife filed a writ petition. He is the second writ petitioner, only to stall the transfer. Thereafter, when we preferred an appeal, before the appellate court, when the appellate court was insisted upon them, then they said, yes, we shall prefer an appeal against it. Then against the same submission before your lordship, kindly produce the documents. The coordinate bench has already passed an order. But I am putting question to myself, my lord, whether your lordship will at all, my lord, deal with this. Well, I am putting question to myself, my lord. But don't take me amiss to that. He knows the transfer is a condition of service. He knows that there is no violation of any rules, because they have candidly submitted at the first instance when yesterday your lordship has asked so. And my lord, the judgment which my learned friend and senior friend has relied upon. But if your lordship kindly see, your lordship has delivered the judgment not on the transfer. It's a panel, a promotional panel. There is the ambiguity vigilance report. That's why that was not accepted by the learned tribunal. Tribunal set aside this. Against that, Union of India preferred an appeal before your lordship. Your lordship upheld the order of the learned tribunal. There is no blood, actual parity with the petitioner's case here. That's entirely, if your lordship kindly go through the judgment of your lordship's judgment. Your lordship kindly go through your lordship's judgment.
He said it is recent.
Not recent. That's
we remember.
That I'm not hard of hearing, but I've heard so.
So we
but
remember.
Kindly go through the.
It is not a transfer matter. That is clear.
Entirely, and your lordship knows the matter, my lord, will depend upon the each of different.
Every
facts.
case has to be.
My lord. Well, this is my submissions. Lord, only to stall the transfer. He is not, because earlier occasion when Lord, this is the second round, when first round before your lordship we have come, Lord, there was a flaw in the order, because honorable division bench in the vacation court, vacation court, where division bench specifically stated that on affidavit it can be sorted out, but that affidavit was not called for. That's why your lordship sent the matter, remanded matter back to the tribunal. Your lordship has said so. We have not gone into the merits. But thereafter, reply, we have categorically said this document is fabricated. It's absolutely fabricated. And there is no denial. Only I deny and dispute. No specific. Yes. But so far as the RTI, my learned senior friend, again and again harping upon before your lordship, produce the documents. You have already availed that remedy. You have said so before the honorable division bench.
And their appeal is pending.
Appeal?
RTI appeal? That appeal has been disposed of.
No, the appellate authority's order, against that they prefer an appeal. Then the appeal is pending.
No, that appellate order they have shown.
Second appeal is pending.
Second appeal is pending.
Then what is second pending? This is my resolution submission before your lordship, and we are suffering because there is see, out of 6 posts, nobody, no industrial development officer is there. Kindly consider the predicament of the state also, state officers also. But this is my resolution submission before your lordship.
Yes, that's all. Then we will hear respond number 6.
I being a respondent number 6 cannot say that the document is fabricated. That is the question of my learned senior friend.
Where is your reply? Where is your reply?
In my from the court. According to me, the documents in the instant application at 117 later of at least July 2020. The anniversary of the company. Out of the aforesaid document, page 77 and 99 were not issued by the copy of the directorate MSN. The documents were totally false and fabricated. I cannot say that, my learned friend. statement. My lord, kindly come to the read petition, my lord. My lord, petition. Respondent number 5. In official capacity, I have the respondent number 5. And thereafter, he has made party to the personal.
No, in the tribunal you were party,
Yes.
personal and official both.
If I am in official capacity, I am.
So you are saying you are entitled to have knowledge about it. Yes. That's all.
And the same transfer order, I'm told that the one man Lord has gone to Mirik also. But so far as the distance part is concerned, Lord,
No, see, distance part, your specific stand in the reply we have just gone through. There is no guidelines in the department for transfer. You have said that the liability of transfer is there. It is apparent from his transfer order, his appointment letter. So there is no issue on which he can
Yes, yes.
claim that it is violating any.
26, 25 already.
So there is no basis for him to say that it is violating any guideline, rule or anything.
I'm deeply
And
obliged.
25 have joined.
I'm deeply obliged. And so far as this judgment is concerned, I have
You
said
only speak for yourself. You don't speak for the state. Yes.
that only Lord, judgment is concerned, I have pointed out.
Yes.
My learned senior friend has relied upon. This judgment
This is
has
not
no
regarding
no
transfer.
bearing.
So this will not apply.
I'm deeply obliged.
That is all.
I give reply to the state's argument. But the argument advanced by the learned counsel for the state talking. But as we have tried to learn as students of law, it is the duty of the state to disclose all evidence annexed in the opposition. That was 1988 for SCC, long time back. The moment the state wants to shield or withhold evidence, the presumption is against the state.
Where is the citation?
And it's 1988 for SCC 534 paragraph 13.
All right. We have taken
4 SCC 534 paragraph 13.
Paragraph
13. Lord, my
Vikram, আছে?
সেন্টেন্সটা বার করে দাও। Please come to page 543. The 5th line from the top of that page, or maybe the 6th line. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence, which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit as the case may be, the court will not entertain the point. In this context, it will not be out of place to point out that in this regard, there is a distinction between a pleading in the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, that is a plaint or a written statement, the facts and not evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the facts but also the evidence in proof of such facts have to be pleaded and annexed to it. Now, it's coming to the proceeding under the RTI Act. Please come to page 166. That's the judgment which my learned friend was, the order which my learned friend was relying upon. Appeal is at the, I'm sorry. Page 166. Appeal is at the behest of the Article 12 authority and directed against an order dated 9th July 2025. By this order, the Honorable Single Judge was pleased to direct inspection of the records.